Good morning, everybody. We're going to look at the second aspect of acting rationally, which is a public law requirement in adult social care and across the whole of any kind of government law, whether it is central or local. Last week, we looked at the aspect of rationality that involves failing to take account of a relevant consideration or taking account of an irrelevant consideration. But today, we're going to look at a more entertaining aspect of acting irrationally, where local authorities have been they've been held up to, I would have thought, a certain amount of embarrassment for taking leave of their senses. And my special features today are a case involving Westminster, Merton, Ealing, Redbridge, Sutton, and Birmingham. I don't mean to be offensive to anybody who comes from those local authorities. Some of these cases were literally years ago, and the individuals involved in them would not now be practicing any longer. But these are the cases, and these are the consequences of taking leave of your senses. So I thought that I would remind you that we're going to look at these cases today, but we looked at last week's cases last week where local authorities had done a really good job and had managed to win cases. I don't want to give the impression that a local authority never wins a case. And I started off with the positive examples last week. This week, I'm looking at the less positive examples. So you can see that Westminster is a case in housing law, but it was where the suggestions for what was good enough for a lady who was in a terrible state, the suggestions were positively eyebrow raising. In Merton, which is a case we've talked about before, there was literally no addressing of the evidence or the parents' concerns about moving somebody from where he'd been 15 years. There was just like cyber robotic repetition. In the Ealing case, it was a case involving a disabled child's plight and, of course, the impact on his mother. It was consistently and ridiculously minimized. And Ealing even had criteria for who counted as a severely disabled child. And they purported to decide that this particular child didn't meet their own criteria for being severely disabled. And that was enough to make the judge cough and splutter as well, but in an earlier stage of the case. The Redbridge case is a pure social care case, a Care Act case, in fact, where there was an apparent deliberate avoidance of the need to address the issues that needed to be addressed. So much so that I wondered if the staff had had their arms put into an arm lock, their writing arms, that is. And then in Sutton, the suggestions there for what was good enough for the man were laughably obtuse. And in Birmingham, the evidence of deterioration was ignored in favour of the pure maths. It was like somebody did a quick sum on the back of an envelope and said, well, we need to change it, but this will have to do. So the first case I want to introduce you to is a case not on that list, but a case that will be meaningful for some of you in a different context. And it's my example of how judges manage to apply common sense, even when they're interpreting the meaning of the legislation. And it's a case from a very long time ago, 2005. It's known as Dee's case. But it was a case where the argument was whether a child's tracheostomy care could be something within the scope of children's social services under the Children Act, or whether that kind of input was inevitably NHS input. And the mother contended that it was either one or the other. There shouldn't be a gap in the middle. And the mother said that because already in that era, the national framework or its precursor was already saying that the government is very clear that there should be no gap between continuing health care or continuing care for children and social services. The judge said this at the suggestion that tracheotomy care for a child should be within the scope of social care, the judge practically choked himself and said this: such an interpretation would turn the Social Services Authority into a substitute or additional NHS for children. That would be to provide an impermissibly wide interpretation, creating obligations on a social services authority which are far too broad in the context of other statutory bodies and provisions covering the needs of children. So, in effect, this amounted to a decision that trachea care for a 3-year-old child was not, had never been, and nor ever would be, a children's social service, even if a parent was trained how to do it. It had to be funded by health. So I expect you're going to say to me, well, no doubt the mother won then. The NHS had to fund it. But here is a really important thing about public law that you need to understand. The local authority was providing some care and the NHS was providing some other care. And the mother wanted more. She said she needed more, but she was deemed to be being well enough supported, given that she was the child's mother. And so the decision was that, having sued both health and social services, the judge was not able to make her the winner against either of those organisations. The local authority couldn't be doing the care because the trachea care was not a children's social service. But the health service gave evidence as to why 27 hours a week of care for her was enough. And the judge said, it is really important to understand that I, as the judge, can only enable people to win a case as far as public law principles actively compel the NHS to do further funding. The evidence had been adequately addressing of the impact on the mother, and the judge did not give the mother the victory. On the good side, though, it's the kind of case that gives legs to the argument that there can be a gap between the legal frameworks for health and social care. And that's something that the government is inevitably hugely anxious about and embarrassed about. If you've ever wondered why there is no list anywhere of services that can only ever be provided legally by a registered nurse, then you're beginning to think along the right lines. The Department of Health is very careful indeed to avoid creating such a list, and also to avoid any more cases where a judge would end up telling the rest of us about what is or is not capable of being a health need. So when people ask me to give them training about where the line is between health and social care, I generally refuse, on the footing that if I was able to be black and white about that, I would be rich and famous. Understanding that the law is geared to make it virtually impossible to come off the fence about whether something is or is not one or the other is the key to understanding the line between the Care Act and CHC. But this is an indication that if there's a judicial review about it, then ultimately it's the judge who decides, and that wouldn't suit the Department of Health. In a case involving Westminster in 2015, this is a housing case, we have a lady called Miss B who had been evicted from her property after she'd been living there for quite a while. It wasn't her fault that the property was sold, and she was offered alternative accommodation, but she never moved in because she feared for her safety. She said she was the victim of attempted murder, 2 attempted abductions, and a campaign of harassment. She was on disability living allowance and severe disablement allowance. She said she suffered from anxiety, panic attacks, IBS and foot pain, but that she couldn't take conventional medicines due to allergies. She'd experienced periods of street homelessness, and she had slept in cafes and night buses, but she tended to stay awake for as long as possible because she was so scared. After the housing department considered the case in terms of whether she was vulnerable enough to be counted as due housing through homelessness, they said this: if you're suffering from anxiety, panic attacks, IBS, and foot pain, you are able to access appropriate medical care from a GP should you wish to do so. Therefore, there is no reason to indicate why this level of care should not be available to you while you are homeless. I expect some of you in the audience are laughing in a hollow fashion at that optimistic approach to what it takes to access GP services. The solicitors, though, acting for her, did not give up, and they gave more and more agonizing details about how this lady was at the end of her tether. And one particular thing really brings it to life, I think. They said when she has an ongoing IBS attack, in other words, sudden and violent emptying of her stomach contents, downwards rather than upwards, she has no choice but to wash her clothes out in a public toilet while being pressured by members of the public. And that is a pretty hideous state of affairs to be in, isn't it? But I mean, in this day and age, the ability to go into a public toilet for hot water would probably be called an asset or a strength, or a community-based route to meeting someone's needs. They continued to say panic attacks, foot injury, exhaustion. Westminster again refused accommodation, simply saying, I am of the view that the reasoning in our first letter is perfectly clear and the decision is entirely lawful. The solicitors took a deep breath and kept going. They talked about her mood and her fear. They talked about the detail of how she manages her toileting and catheter needs. And they talked about the extreme sleep deprivation that she was going through. Believe it or not, Westminster did not change their mind, and she brought judicial review proceedings. The response to that particular catalogue of doom from the solicitors was surprising to the judge, because it said, you've not given us any new information in relation to medical conditions, and these have been fully addressed in my previous letter. The judge said, it does seem to me the council has not carried out the due consideration which is necessary. The other solicitors had referred to HOTAC, which is a case on vulnerability, and says the council came back and was still satisfied that Miss Barrett was not going to get them to change her mind. So as far as the judge was concerned, this council has not given conscientious consideration to the necessary matters. Maybe the original decision was just about okay, but the subsequent 3 letters, particularly the first and the second, were unlawful, and the proper course is that the defendant counsel must reconsider the matter. And this brings out that when you win a judicial review, you don't automatically get housed or get community care or get children's services. You get the chance to have the local authority do it again, second time around, legally and properly. But if people stop using judicial review, then the principles start to evaporate. The clarity of the legal framework, even though it is nuanced, ends up getting very, very foggy, and people leave the sector and they can't download their knowledge to the next person, because day by day, the legal framework is becoming less and less important to people, whereas people like me think that it has never been more important. Merton is the leading case on reassessment in terms of adult social care law. And this is a case where the gentleman was going to be moved from a facility where he had been living for over 10 to 15 years, and he was very happy there. Merton told his parents that he no longer needed what that organisation had to offer. And therefore, since it would be meeting wants rather than needs if he were to stay, he therefore had to move. That decision was quashed by the court, holding that the decision to terminate that contract was clearly irrational, because there simply were no reasons that Merton was able to be giving to anybody to justify the idea that there'd been a professional social work decision that the plan was no longer needed and that the element of the plan was no longer needed. So you can see that it isn't okay to get artificial intelligence or a resource allocation scheme to do care planning. It isn't okay to get somebody who knows nothing of social work values or training to be doing decision making. It's no good getting the chief finance officer to be doing care planning on the footing that any old local authority person can do. There has to be a semblance of a proper thought approach to the decision. Otherwise, it will be irrational. The judge was a woman judge who explained very usefully for anybody going through a reassessment what can make it unlawful. And the case is a classic public law decision. It's not a court of protection one where the focus is on balancing this, that, or the other for best interests. It's a classic judicial review, one of the few that there have been about the Care Act. And what this case means is that commissioners cannot constrain their colleagues' care planning judgments in advance just because of the budget. Saying to themselves in a meeting, it's got to be cheaper for the next year is not wrong, but it's got to be cheaper regardless of the needs is definitely not okay. And the judge said this: no reasonable local authority would terminate the placement of someone with JF's complex needs without having conducted a lawful assessment of those needs and without having lawfully decided that suitable alternative accommodation was available that would enable them to meet his needs. So it's very difficult to see how the decision can have been in compliance with the statutory duties in the Care Act and in the assessment regulations. I have found that the assessment was not lawful for the reasons given above. The decision to terminate can therefore not stand, regardless of the date on which it was taken, etc., etc., etc. So I want you to remember that Merton is the leading case on reassessment, rationality, and legality. That's an adult case, but this one is a disabled child's case. And this is a case where the old reference to Wednesbury unreasonableness was made. Wednesbury is a municipal council. I don't think it exists any longer. But back in the 1940s, it kicked off the modern era of judicial review. And Wednesbury Corporation was found to have acted unreasonably by taking leave of its senses. So this level of unreasonableness is called Wednesbury unreasonableness in legal language. And the mother and her two sons needed larger accommodation, and they went for it under the Children Act under Section 17 because one of the sons was severely disabled. He was 9 years old and he had profound eyesight problems, dyspraxia, dyslexia, and severe asthma and incontinence. The bed shared by the boy and his mother was a double bed, and it took up all the space in the room. And the judge said, startlingly, no one responsible for the decision or making an appropriate assessment on behalf of the council went upstairs and actually looked at the sleeping accommodation. And you can tell from the tone of my voice that I'm thinking that that was a big shot in their own foot. If you're going to make assertions that somebody's accommodation is adequate, then it behoves you to actually go and look at it and perhaps even measure it. We have used this principle recently in respect of a woman who had very, very severe infection control issues around her condition. And she was on a form of medication which kept her comfortable, with her physical disability, but if she got an infection, she needed to come off of it. And therefore, it was crucial that she had a particularly clean setting all the time. And the council argued that nobody needed more than 2 hours a week to remain in a habitable home environment. But she lived in an annex. It was a particularly large and spacious annex, good for somebody who was always going to be wheelchair bound. And the local authority, again, didn't actually go and look at it. And they did a kind of map of it in terms of its measurements from the local planning application, but they didn't go and look at it. And they argued with the carer as to how long it took to change an electric bed, whereas the carer was offering a video so that they could see it took twice as long, refusing to consider the evidence and actually not going. In this case, the judge said both the decision and the decision-making process were flawed. There was no analysis of the accommodation problems being faced, no proper reasoning, failure to ask yourself the right question, failure to take reasonable steps to gather the information up. That is acting irrationally and unreasonably in the Wensbury sense. The suggestion of bunk beds made halfway through the hearing maintained a general pattern of ill-considered proposals. Was the brother's life now to be further disrupted? Was the idea of these bunk beds that the mother and the son should share them, even though the boy could not get out of bed until he had his glasses on? If so, for how long? How, in truth, was this crazy proposal going to happen? And so ultimately, Ealing lost that case. This case, coming back to the Care Act, is my favourite case about how local authorities need to be very alive and act rationally when they're told about urgent needs. This is the famous Ali Raja case involving Redbridge, where a mother who was absolutely dedicated to her 2 sons, who had severe physical and learning disabilities, would do nighttime care. So ultimately, they needed positioning several times a night. And back in 2017, the mother was reasonably expected to reposition her disabled sons at nighttime single-handedly, despite having her own health issues. As far as she was concerned, she was not unwilling, and she did not dissent from this view. No doubt it meant, or it was conveyed that it meant, that the men would be able to stay at home and not go into institutional care if she was willing to do that. Later on, though, her lawyers sought urgent nighttime care as her health had declined, and she said she could no longer cope. When she said that, Redbridge did nothing or positively declined, and she went to the High Court and got 10 hours of funded nighttime care for her sons, and that was repeated twice over. When the case finally got to the full hearing, which can take a very long time, the council lost, and it was told that it had to continue the funding. It was the sole justifiable response to the situation on the ground for this family, even though there had not been a concluded reassessment, and even though the men were in the system already. When it came to the judge's analysis of the case, the judge said, nobody grappled with the central, straightforward question in this case. Was the mother reasonably to be expected to be able to reposition the claimants during the night time? You have to be both willing and able to be a family carer. You have to be willing, and of course each person is the judge of their own willingness, but you have to be objectively evidenced to be able and capable, because if you're not, then you're just putting the person at risk. And that's what local authorities sometimes have to decide. Nothing in the documents provides reasonable support for any conclusion that the mother could reasonably be regarded as able to reposition the sons at night. I have been able to find no evidence that the defendant counsel, and certainly anyone with decision-making responsibility, ever asked itself that question, and if they did, as to how they answered it. And of course, if you work for a council, you can imagine what the council did say. It said that the nighttime care was not needed because, obviously, the mother was continuing to be involved. She had provided witness evidence that she did and was continuing to reposition her sons herself, even when the carers were there. She said she was always present at night, offering additional support, stating that she often slept next to one of the men in order to offer this. And she said, before we had overnight carers, I would be solely responsible. However, I still choose to assist the workers when they provide physical support. And so the council basically said, well, if she's doing it and she's choosing to do it, then she must be regarded as able to do it. And that's what the judge said was not the right reasoning. The council was not entitled just to take the mother's continued dedication as proof that she was able. Mrs. X had also explained to the court, with evidence from her GP, as to why she could not be regarded as able, even though she was trying. I need surgery to relieve pressure on the spinal nerve. Proposed surgery has a recovery period of 6 weeks. I am unable to walk except for short distances. I cannot walk outside. I am in pain when I stand. I've had a further MRI scan which shows a degenerative problem in my spine, which is unlikely to be fixed. I also have a problem with my right shoulder, pain to my knees and neck, and high blood pressure. Caring for these men is extremely physically demanding. The most demanding part is turning them at night, and I cannot physically do it anymore. Mr. Justice Fordham said this: the court was shown no document which addressed the question whether the mother can reasonably be expected to reposition her sons at night single-handedly, and which concluded that she could. She wasn't saying that she was unwilling, but she was saying she was unable, and that assertion had to be addressed to be public law legal. Coming now to one of my favourite cases, this is just before the Care Act under the old law, but the principles have been the same all the time. This is the case in which Sutton finds itself responsible for a gentleman, Mr. Clark, who has been living in a block of specialist supported living flats in Sutton for 4 years without Sutton even needing to know about him. And that was because his care package, which was expensive, had been cheerfully paid for by Enfield, even though Mr. Clark was no longer a tenant in Enfield. He had severe epilepsy, mental health problems, and challenging behaviour, and he was definitely ordinarily resident in Sutton. At that time, Sutton should have become responsible for his care, but in fact, because Enfield was happy to keep on paying for 4 years, they had never needed to. When Enfield got fed up with paying, Sutton dilly-dallied and didn't even carry out an assessment until 5 months after Enfield ceased to be willing to pay, but that's another matter. The conclusion of the assessment was that the man did not need specialist epilepsy care. The Sutton care plan costed his needs at £357 per week, compared to what he was having for £1,300 a week. and Sutton refused to continue to contract with the old council's provider. And as I'm sure you know, in that kind of a specialist setup, the care provider usually has something to do with the landlord. So the gentleman had a tenancy that was separate from the care package, and he couldn't be thrown out just because the care provider was no longer the contractor. But the care provider took legal advice and helped the young man go to judicial review. And he got an interim injunction to stop Sutton from refusing to pay. The evidence about the care had been very clear from the specialist provider. There was a bespoke alarm system. There were staff who were good at all emergency medication, and there was highly skilled management of the seizure activity before and after an attack. And there were waking night staff. There was specialist evidence from a neurologist and an epilepsy nurse, and it was accepted that the man had 1 or 2 unpredictable tonic-clonic seizures per month. So Sutton raised the amount that it was offering to pay a little for hoiking it round their commissioning framework, and they said on their one-page profile that Mr. Clark needed waking night support for 3 nights per month. The reality of that would be, of course, that the provider would be on risk as to which 3 nights that was going to be. And unless you had a crystal ball, you wouldn't have been able to tell. So what was wrong with this approach, as far as the judge was concerned, was that it failed to allow for the fact that supported living works on a business model of charging by the week, not by the minute or by the hour. So offering a care plan that just provided support for specific tasks, as if he were a home care client in the ordinary manner, or these 3 nights a week out of 31 nights per month, sorry, the 3 nights per month out of 31 per month, was simply ridiculous. It was the only way he could live outside of a care home, and it was crazy of Sutton to fail to take account of that model. So finally it raised the sum of money to £661, but it couldn't explain how that £661 would meet the needs that it had been by then required to reassess. It found another provider, but there was no evidence that made it really clear that that new provider knew what they'd be taking on. And of course, crucially, it was going to involve this chap getting up and moving from one place that he called his home to another address. And it wasn't as if the local authority was offering to pay his rent. He would be paying his own rent. So Sutton needed his agreement before this care plan could make any sense at all. The judge held that that allocation of funding was completely irrational, and the expectation that he move to another house a breach of his human rights. He did say that that was happening in this case because this is a man who's been in receipt of these services for a long time and his needs have not decreased. It wasn't the same sort of consideration that he might have given the chap if the chap had been arguing about a first care plan. But in fact, of course, it was a new council. It was a kind of new care plan, not an ordinary revision or a first off one from not knowing the client at all. The judge said that the 3 waking nights care offer a month simply does not make sense. It does not address the needs identified in the reports. And this tenancy has been his home for more than 4 years. There was no care plan produced from the proposed non-specialist care provider. So this was unlawful. Relevant circumstances had been ignored, but there is this irrationality as well. Sutton was taking leave of its senses. The decision failed to give appropriate weight to obviously relevant material and relied excessively on the non-expert view of a social worker in the face of a wealth of evidence from qualified and experienced experts. And that's why it says in the Care Act guidance that if a professional feels themselves out of their depth or not good at awareness of the particular condition that a person is presenting, they must consult people who are competent. They can't just look it up on Google and think that because they can pronounce the name of the condition, that that's going to come across as competence. So the judge went on to say too, that expecting him to move from a place of his choosing to a place where there isn't even a care plan to convince him that it would be okay, that's a breach of his human rights. We go further. We take this case to really turn upon the fact that nobody is entitled on the part of a local authority to get a person to move from their house as a condition of adult social care. At least not as a condition of adult social care that is not in a care home. A local authority's placement in a care home is within its gift. If it thinks it's necessary, that is its offer. But if a local authority thinks that an individual is going to be okay in supported living, they still need that person to agree to go and live there and sign a tenancy and pay rent. And there's nothing in the Care Act that says that the duty to meet needs is able to be lessened by somebody's refusal to go where the local authority wants them to go and pay their own money for something that they don't really want. So I'm thinking that if the Care Act had been in, this case could have been stretched to go a bit further in terms of useful principles for people with disabilities. And then finally, we come to the Killigrew case. This is the best case on poor process regarding revision of a care plan. The care plan was reduced from 12 hours a day to 6. And it was not because the client had suddenly got half as well again. Their needs hadn't gone down. What had happened was that they'd been having 12 hours a day from husband and paid carer. When the husband could no longer do the manual handling, that was going to mean that the 12 hours were going to need to go up to 24. And I've rather ruined that, haven't I? The bottom line was the care manager thought, 12 hours times X pounds per hour equals such and such. If I've got to get this coming in at the same price, but the person now needs 2 carers, well, obviously, division is quite a simple bit of maths. We just need to divide 12 by 2 so that we get 6 hours a day. But that left large tranches of the day literally without cover. So the judge referred to something that was written as long ago as 1993 by the then Chief Inspector of Social Services. And it said from that august person that before any changes in services are made for existing users, they should be reassessed. And if the position is that the need is no longer there, and that's the local authority's position, or if the need has to be met in a different way, there must be explanation. Explanation is the key thing. So where was it in this case? The local authority said that the 12 hours had really just been largely spent keeping this lady company. And the judge said, that's very interesting. But if it is the case that 12 hours of that is no longer needed, the authorities need to articulate how that can possibly be the conclusion. This lady is inevitably and steadily deteriorating. And without those 12 hours, there are likely to be serious consequences. On the evidence, the judge said, the reduction could only be justified if there was no continuing need for 12 hours care, not simply because 2 carers were suddenly needed when only 1 had sufficed earlier. There was no proper analysis of why the original care plan had been regarded as needed. The council can say it doesn't want to provide effective emergency care because it can't afford to, or it's not worth it. But the point is, the local authority needs to consider what will happen if there is an emergency and no one is supervising her. Before any conclusion about the merits of providing a service, even though the risk is very small, could be arrived at, the judge said a great deal more has to be done by way of examining the condition in which the person finds him or herself. So the takeaway lessons from this case is this: the barrister invited the judge to say no reasonable person could prepare a scheme for this applicant that did not involve 12 hours continuous care. The judge said, I cannot accept that submission. I'm not the care planner. I'm not the social worker. But I direct that this matter be referred back to the respondent for reconsideration of the care needs. Judicial review, ladies and gentlemen, is the only remedy for enforcing Care Act rights, and it does the job. But it can only work if people who draw on the services, their families, their friends, their advocates, and their social workers, they're social workers of whom they can absolutely legitimately expect competence, professionalism, and empathy. All those people have to know the legal framework that sits underneath the rhetoric. And if we don't use these public law principles, if we don't go to court, but we don't even use these public law principles in correspondence, social care rights will simply die from disuse. And my view is, and CASCAIDr's view is, that we will all be the poorer for that in terms of a decent quality of life in our hour of need. It's probably going to be longer than an hour. I am very shortly going to have to go today because I have a personal obligation, and as ever, I have gone on for longer than usual. But is there anybody who wishes to ask a question at this moment? Is there anybody who would like to ask a question? Because I have a couple of minutes and I'm able to open up the thing. Madeline, can I ask you to unmute? You've got your hand up. Yeah.
Yeah, hi, can you hear me? It's John.
It's not Madeline again. Hello, hi.
It's John again, unfortunately. Yeah,
hello.
She'll make an appearance sometime, so to be quick.
Yep.
Yeah, the pattern of unlawful decision making, it never seems to sort of pull through to local authorities not making unlawful decisions, and there seems to be so many similar formats of the same types of decision, but they never seem to go from one local authority to another or one NHS authority to another. They seem to say, oh, well, it looks like we got away with it last time. Let's see if we can get away with it this time. Where does that end? Is there anything that's in the system that says, look, you either know the law, people who provide funding for this, or you don't know the law? If you don't know the law...
It's an interesting question.
Yeah.
My feeling, having been a trainer of local authorities and also having been a sort of a lawyer in this charity, is that judicial review is a peripheral and rather ad hoc way of enforcing rights. But if it doesn't exist, there is no stick to beat anybody with. Now, the carrot of training, because it's exciting for staff who've got high hopes and ideals, the positivity of training can be more persuasive if you've got good senior management. But the reason I had to start the charity was that the local authority world became tired and too poor to afford the training. And therefore, the answer to your question is, where does it stop? it might be that the Ombudsman is the answer, because I think that the Ombudsman is going to become the way forwards for this principle. This principle would be, if the law is clear and the cases are there, how can it be good administration not to know them? And that's the only hope I have of a kind of a sort of a refreshment of interest in adult social care law principles, perhaps brought about, ironically, by more and closer integration with the NHS. That's all I can really think of to say.
Okay. It sounds like give a busy service even more work to do, though. The Ombudsman, again, is...
But it doesn't mean that people shouldn't learn adult social care law, because they need to in order to make their complaints. Absolutely. So thank you very much. I'm really sorry I have to go today, but I have to pick somebody up from the station. All right. Thank you. Cheers.
Thank you.
Bye.
Thank you.